Hello everybody. Quincy and Annika and I are here to speak to you about forensic assessment in civil cases. And we also have a homework assignment built into this one. Stay tuned. I'll be talking about the various components. I think there's 4 components of the homework assignment. So here we go. Notice we're following up on forensic assessment in criminal cases. This is also done in civil cases. Criminal cases, someone has violated a law, right? When we get to civil cases, we really are talking about resolving conflict to a greater extent, that 2 parties disagree, one sues another, for example. So what are we including here? Potential areas of expert testimony in civil cases, and that's what we need to talk about. First and foremost, experts are called to serve as witnesses, right, to persuade jurors or judges this side or that side should prevail in a civil case. So it might be psychological damages to civil plaintiffs. So if something occurs, if my workplace continually subjects me to harassment, and I complain and they do nothing about it, and I develop some kind of psychological consequence as a result of their inaction, then I may choose to sue my employer, right? But then I have to present evidence that I was in fact damaged psychologically, and I also have to provide evidence that that damage is worth X amount of settlement. So you kind of get the idea, and that's just kind of the general overview. It may be workman's compensation claims. So that is, perhaps something has happened to me at work and I file workman's comp and they deny it. It might be assessment of civil competence. Civil competence in this arena is not like, am I competent to stand trial? This is competence in terms of engaging in life's tasks and decisions. More on that as we get to that point. Psychological autopsy. And often this is, boy, did this person die at the hands of another, or was this natural causes, or was this suicide? So the psychological autopsy is after the person has passed, right, is to try and get into what's going on in their head. And interestingly, my wife, when she was working in contestable claims at Nationwide, that is claims that the insurance company doesn't want to pay out, is contesting the circumstances under which the claim was made. This is something that she actually had to do now and again, was look at, was this actually a suicide or was it not? Okay. Child custody, parental fitness is another place where competence may be assessed. And then civil commitment and risk assessment. That is this person presenting such a danger to themselves or others that they should be put into a mental hospital of some sort? Now we return to this idea of, okay, we've got expert witnesses who are providing us with testimony. Is this testimony scientifically legit? I mean, is it empirically supported? And the judge is the gatekeeper in this regard. The judge has the ultimate say-so on whether this information, this testimony, should be allowed or not allowed. If an attorney objects, I object to the nature of this testimony, then everyone approaches the judge's bench, and the judge has got to make a ruling whether this testimony will be allowed or not. Problematic, right, for judges, because judges have typically been lawyers. That's how they're trained. So their science training in college, right, and law school might not be, I don't want to say this to insult judges, but not as good as it could be for having to make these kind of determinations. And it's a shame because it appears that the legal system is often putting people into situations where perhaps they're not as qualified as they could be, right? So keeping junk science out of the courtroom, there's some standards. In Daubert versus Merrill, right, we talked about the Fry standard, etc. Well, Daubert applies to scientific methodology. So the idea is, to what extent is the methodology embraced by people in this area of science, right? And to the extent that methodology is in question, or new, then people might be more doubtful about the efficacy of the procedure and the conclusions we can draw from the procedure as used. Now, Kumho-Tyre versus Carmichael extended the observation to technical knowledge. So now we're not necessarily talking about vetting the discussion that's being made by scientists in court, but it might be understanding the testimony that technical experts are giving in court, right? So if there's an issue with, let's say, the rubber quality in tires that leads to some severe accidents, and it's discovered that the company knew about it, but to what extent did they know and what did they know about it, then we might have experts in the manufacture of rubber or tires who are testifying, and is their testimony allowable or not based on its quality? Well, unfortunately, the ability of the judge to perform this function is often, or at least sometimes, in doubt, right? So this leads us to our first homework assignment, first part of the homework. This is homework 8, part A and B, part C on the next slide. Let's first consider the role of judge as gatekeeper. What does the statement judge as gatekeeper mean, right? So first I'd like you to define that. And then imagine yourself as a judge. What type of evidence would just scare the shit out of you in attempting to play the role of gatekeeper? You know, I'm on the Committee for Academic Misconduct, and I hate trigonometry and calculus evidence. I didn't take those classes, and deciding the quality of evidence that I'm being presented by a professor and a student, right, and COAM, can lead me to significant kind of turmoil, and it's really a challenge. When, you know, someone is saying, hey, this answer would not be derived by a student of this level, right? And therefore, this answer is obviously an answer that came from somewhere else. And the student consulted another source, and it's like, well, I don't know. I mean, is what the professor's saying true? And then the student responds, is what the student's saying true? But fortunately on COAM, right, we're a panel of 5 members, and we're distributed throughout the university, so there's going to be a couple people on the panel who can kind of clarify that evidence. Now, I mean, we could ask questions, but ultimately it's hard to judge that evidence at that point for some of us. So what type of evidence might be presented in court would make it tough on you? What type of evidence do you think you're better qualified to judge the quality, right? So this is just, we're just exercising our way through this part of the dilemma, if you will. And then part C, what might be the remedy for judges B? Please note the slide entitled Potential Remedies has little to do anything with this question. Those potential remedies are for juries, and the slide I'm referring to is coming a little bit further in the lecture. So if you think you got a shortcut, say, oh, shit, Mark put this slide, potential remedies, I'll just take something from that and answer part C on this question. It's not going to apply. So I'm just warning you off right now. Problems to psychological or psychiatric evidence, opinions? Well, scientific foundation of evidence might be weak, especially with psychological or psychiatric evidence, right? Testimony might be a little relevance, and who's going to understand that it is or isn't? Experts often allowed to advance ultimate opinions when juries should be allowed to come to a decision, and that as expert, you know, ultimately, what do you believe is the case? And maybe the expert witness really doesn't have the empirical support to go there. How does a jury or the judge know that? The limits of the testimony. Expert testimony can open the door to hearsay evidence, and that is not typically allowed. So problems to psychological, further psychiatric opinion or evidence. Adversarial system, right, can bias presentation or compromise objectivity. And this gets back to the issue of paid witnesses. If I've been hired to provide information, to provide testimony, if I've been hired to do it, to what extent am I still objective? I got to check one thing real quick here. All right, so I just want to make sure that's on. Testing presented evidence is often inadequate. Attorneys do cross-examination, but remember, attorneys are the product of law school, and it might be difficult for them to fully explore the empirical support for scientific or technological evidence, right? The spectacle of disagreement casts doubt on the science of psychology. And we talked about this in lecture 10. When you have, one psychiatrist saying, hey, this is the nature of the disorder and this is what it means and this is what it leads to, and someone else is saying, no, that's not the way it is, it falls far short of that, or we can't draw that conclusion. Note now that psychological testimony is under great scrutiny and falls under question, like, okay, so what are these psychologists, since they don't agree, who is right? They're both supposed to be scientists, but they're disagreeing. Is psychology then actually a science? Or is it just a fancied up form of opinion? I don't even want to go there. Now, potential remedies, this is for juries, right? Allow clinical opinion testimony only if it satisfies the standards of Daubert or Kumo. If it falls outside those standards, then the judge needs to disallow it, right, so that the juries don't hear it. It would be really perhaps cool if we could ban the reference of witnesses as expert witnesses. Rather than call it expert testimony, maybe we need to be more not automatically lend the same level of credibility to it and call it opinion testimony. Expert testimony implies, hey, this is golden, right? Opinion testimony means it's open to analysis by the jurors, and the jurors should be allowed to rule on it either way, rather than take it as handed down from on high. I want to limit the number of experts that can testify, but notice that each one of these suggestions, these potential remedies, has cons associated with it as well. And true to the nature of this course, pros and cons, right? Consider it. Eliminate bias by employing non-bought witnesses. That is, that we have maybe witnesses that are employed by the court rather than hired by the district attorney or the defense attorney. And that's kind of an interesting thing, to consider, is that you randomly assign expert or opinion witnesses from a pool to cases and assign them to either side. So that, today I might work on this case where I'm working on behalf of the prosecution, and then the next case I might be randomly assigned to working on behalf of the defense. What does that look like? Is that something, obviously you can see some pros as I put it, but what then might potentially be the cons? And one thing I've noticed in your discussion boards, guys, you are eminently capable of anticipating both pros and cons. So my kudos to you. And maybe we need better jury instructions so that the jurors better understand their role and responsibility in assessing expert or opinion testimony, whatever term you want to use. So that leads us to part 2, A and B. All right. So, while on the topic of potential remedies, let's focus on the last two in the slide so titled. Eliminating bias by employing non-bought witnesses and better jury instructions. So for part A of number 2, for employing non-bought witnesses, how might that be accomplished? I mean, it seems a bit out there, doesn't it? But are you stumped? You can talk through this in our weekly session, but just kind of imagine and devote a paragraph or two to what system you might create to eliminate this bought witness phenomenon. What might a system to replace that look like? Right? And complete answers, of course, say, hey, this is what we would intend to do, but this is how it could potentially backfire. Now, B, for better jury instructions, what are 3 critical take-home to the jury box points that you would want to make in the jurors' minds? So, you got a bunch of people who are drawn from the community, that's our jurors. What are 3 things you think are most valuable for them to know, to consider in evaluating expert testimony? And note, there is not a right or wrong answer to this question, but obviously, as in anything, there are better answers and less awesome answers when you get right down to it. So as some of you have pointed out, in answering these homework assignments, you say, it seems like you're assessing quality of thought, and you're right. We're looking at quality of thought, depth of thought, seriousness of thought. especially when we get into these realms where there is no right or wrong answer. Now, homework 8, part 3, A and B, and this one is along the same lines. This one, though, might be controversy provoking, but you all are up for that, right? So, given the potential for increasingly technical nature of forensic scientists, should there be a minimal education requirement for a juror? What I'm thinking here is, let's suppose someone drops out of high school in the 9th or 10th grade, and they really have never had a science class. To what extent does it make sense then to have them on a jury where they might have to determine good science from bad science? Now, I know this is controversial. I'm just putting it out there. I'm not stating my opinion. I don't know. I don't think I have an opinion. I have a long list of pros and cons to these ideas, but I've certainly not worked through to come to some kind of conclusion. So, what's the potential requirement then, as an example, if we do want to have a requirement? So, at answering this question, at some point you have to say, well, if there was going to be, and I might not agree with that there should be, but if there was going to be a minimum bar, this is what I would make it, right? And then, what might be a pro and con to this educational requirement be? And I'm putting it as an educational requirement. Maybe you have a different term that you want to use or a different angle of attack on this particular question. So maybe it is a problematic idea. Shall we try a different one? Should jurors be trained in assessing evidence quality prior to hearing a case? So that is, you've been selected for jury service, you're going to have to attend this training, and we're going to take care of it for you. Right? What might that training look like? And of course, a pro and con to that. Okay? So really, we're kind of trying to address this from our imagination, but based on what we know about science and what we know about the law. Let's move on then to assessing psychological damages. What happens when we assess psychological damage to a person? We have, you know, a plaintiff, we have a defendant, they're suing, let's say, a company, they're suing a doctor, they're suing someone, a drug manufacturer, what have you, for damage they've received. Well, some of the things we're probably going to want to know is the personal social history. There's probably going to need to be a clinical interview to test the nature of the damage. And there's probably going to be forensic measures, psychological tests to determine the nature of the disorder and or the disability, if you will. There is no established procedure for this. Right? And think about this. Plaintiffs, would you believe it, might exaggerate or they might make shit up to receive a higher settlement or to receive any settlement at all. How do we know? Well, one standard instrument is the Minnesota Multiphasic Personality Inventory, which we've described earlier in the course. And this is to detect the existence of mental disorder, and it's a robust clinical tool. The problem is that the F scale, that's the lying scale, the fabrication scale, etc., and various other scales, there's been research to demonstrate that people can be effectively coached to cheat the MMPI. So then we get into this issue, right, that if it's possible to cheat the MMPI, is this instrument compromised to the extent that maybe it should be abandoned and something else should be used in its place? Another strange issue, right? So, workers' compensation cases, another area where forensic assessment is maybe going to be employed. So, basis for claims? Well, maybe physical, mental. So let's suppose there's a loss of an arm causes pain, which leads to depression. How do you demonstrate the nature of that injury and the value of that injury? Back in the day when I was a kid, I remember learning this, probably, it seems to me in 6th grade, and it kind of intrigued and astounded me. It was about insurance. And you could get disability insurance, or companies, you know, built-in disability insurance. Because this is prior to the days of what we might call now excessive litigation, especially in civil cases. The idea was this insurance policy covers you. If you lose an eye, you get paid $25,000. If you lose both eyes, then you get paid $100,000. If you lose an arm, that was worth $10,000, right? I mean, the amounts, the payoff amounts were already set on the basis of the nature of the injury, right? But now notice that it's far more fluid. So the loss of an arm causes me pain, which leads to depression. What is that worth? Okay. Mental. An event causes psychological trauma that persists, like I'm engaged in a robbery that leads to post-traumatic stress disorder. And I want to sue my employer as a result of this. Right? What is that worth? How do we determine that? And then, like physical, work-related stress causes high blood pressure. And to what extent, then, should I be compensated for such a thing? And how do I demonstrate that that even occurred? So you can see how difficult it is to maneuver on this playing field and come to rational, empirically supported conclusions. We're really in the realm of opinion on much of this. Now, psychological autopsies, these are retrospective because the person is gone, right? Was it suicide, murder, or an accident? And like I said, my wife, when she was doing contestable claims, this is an area she worked, and she always brought me a lot of fascinating cases to ponder, right? Because if it's a suicide, and usually most life insurance policies, for the first 2 years, if it's determined to be suicide, you know, if I get this policy and within the first 2 years I commit suicide, then the policy typically doesn't pay. Now, after 2 years, almost all policies will pay for suicide, but it's that first 2 years. So, you know, I say, hey, look, you know, my spouse died, and the insurance company, I want you to pay up that $250,000 life insurance policy, and the life insurer comes back and says, you know what? We're not convinced that wasn't suicide. And since this is in the first 2 years, we have no obligation to pay. See, it's a contestable claim. The customer makes the claim, but the insurance company contests it. And so suicide, was it suicide paying death benefits, workers' comp, right? Or the legitimacy of a will. All these aspects can be pulled into what was the person. You know, if a part of a will, let's say, is unclear, what did the person actually mean by that? How did they really want this distributed and to whom, right? Were they actually, when this will was produced, competent to do so? And the fascinating part of these questions is they're all retrospective. It's trying to build a picture of what the person wanted at the time or what their motivations were. So interviews with third parties, prior records, but ultimately, this is not a very reliable system. Now, where else might assessment take place in the civil case? Well, child custody, right? Future best interest of the child is usually what guides these processes, especially when we're talking about children who are young enough that they really can't state for themselves. If we're talking about 12 or 13-year-olds, judges often interview the children and allow the children to have a strong voice in making the decision. But if we're talking 4, 5, 6-year-olds, probably not capable of doing that. And now notice the emotional stakes are often extremely high in this case. Remember we talked about that judge flipping the coin to determine where the children will go during Christmas holiday? What are the parents doing that make that necessary? Can the parents not make an agreement? My mom and dad divorced when I was 4. And they could always work it out where I would go at various holidays, etc. I mean, my parents were cool in this regard. As far as divorced parents, they didn't dish on each other much, and they were very cooperative with each other. So I was shielded from any kind of conflict over me. If it was occurring, it was coming outside of what I was aware of for the most part, right? So emotional stakes can be extremely high if people are contentious, right? They need to evaluate many people, and some of these people won't cooperate. So they might talk to the father, but then the mother doesn't want to talk. But then they might talk to the maternal grandparents versus the paternal grandparents. One side is freely speaking, the other doesn't want to contribute, right? And somehow you have to then render a valuable expert opinion. It's an individual situation. All of them are different. Hopefully there's some knowledge of child development guiding the opinions in these cases. It can be extremely adversarial. Experts need to expect significant challenges and to have their expertise actually attacked. And notice, what we see now, isn't that interesting, that if you provide testimony as a clinical psychologist, you will personally be under attack by the other side. I mean, so far as maybe launching at your degree or some aspect of your background. Questions? Let us move our conversation on to the issue of civil competence. Pay attention, guys. I hate to be the harbinger of bad news. Maybe you already know this. But for many of us, this is something that we're going to have to deal with in our lives. And it usually has something to do with our parents, our grandparents. And I've been through this over the last, 6 or 7 years. So I'll share some of those realizations as we move through this process. One of the basic questions, though, when we talk about civil competence is, does someone have the capacity to understand information and make informed choices? And this might be about their financial affairs. This might be about participating in medical or psychiatric treatment. Maybe to execute a will and decide how to distribute property. The question is this person competent in these domains? What about advanced decisions about medical care or life-prolonging treatments? And this falls into the heading of what's called advanced directives. And one of my questions for you at this point is, do you have an advanced directive? I mean, I realize that you are 20, 21, right? 22 maybe. What happens if you're in an accident that leaves you in a vegetative state? What do you want done? Do you want to be maintained on life support for 10, 15, 20 years? Do you want to authorize someone to make the decision of when to pull the plug, so to speak? Under what conditions would you want this to occur, and on what conditions would you not want this to occur? Right? So both my wife and I have advanced directives, and it spells it out. Hey, if this happens, I want this. If this happens, I want that. If this other thing happens, then let's do this. Right? And it's a super unpleasant thing to think about. But often we don't think about this because selfishly it gives us the EBGBs and we don't want to worry about it or consider it. But the unselfish thing to do is often to sit down with someone, consider what could occur, and make your wishes known to them. Because when you're not able to make your wishes known, when you're on life support, think about the poor people that are left behind. They may feel amazingly guilty. They may not know what to do. We may be looking at horrendous costs to be incurred with absolutely no possibility or minimal possibility of those costs making anything useful happen. Right? So it's a horrible thing to think about, but to be realistic and be kind to the people in your life, it's something to consider. Right? And obviously as you age, it becomes more and more important. Interestingly, my undergraduate advisor, Pete Ditto at UCI, some of his research long after I'd left the school was on advanced directives. And what he did is his sample, his participants in his studies were elderly couples, right? People 60 and older. And what he would do is he had questionnaires, he would survey them. What do you want done to you under this condition? What would you like done under this condition? What would you like to done with this terminal illness, etc.? So he collects that, let's say from the husband, and then he goes to the wife and asks the wife, what would you want done to yourself? And then the second part of the questionnaire is, what do you think the other person would want for themselves in this condition? What he found was that people only guessed right about the other person about a third of the time. So it really is good to have the conversation and get this on paper so that people know what the hell to do. And how it was as interesting is because these patients, these people, these participants were old, and this is why Ditto used that age criteria. He could longitudinally study and see what actually happened when that time came in certain cases. And again, the predictions were notoriously inaccurate, even with the conversation. Now, let's talk about the assessment of competence. And my mother went through this with her husband, Howard. And my wife and I went through this with my mom. Howard went down the road to dementia very severely, and my mom had to eventually assume control of just about everything, and he was eventually put in a memory care unit. 10 years later, my mom started demonstrating signs of dementia and a supporting diagnosis by her doctor in a very early stage. But then we had to start making provisions for us to take care of her. And it was funny, some of the skills that began to erode pretty quickly is my mom, would read often, and she stopped reading because she just couldn't track it anymore. Reading became useless because you can't remember what you've read from one moment to the next, so there's no continuity in what you're reading. It doesn't go anywhere. She also really kind of lost her ability to do mathematics, and that's an ability she had before. She was an executive. She was a casting director. She managed, budgets for hiring actors on shows, etc. She successfully budgeted throughout her life, but she began to lose that ability. So as her abilities started to erode, then my wife and I started to take them over. And fortunately, my mom had, good advance directives and was willing to give us power of attorney, etc., and all these different powers. So as she lost her abilities, then we could begin to take that over, manage her finances, etc. What needs to be done, though? See, my mom voluntarily participated in this. But what if your parent says, hey, there's nothing wrong with me? And it's like, like my buddy Tim. Both his parents descended into dementia kind of simultaneously. It's a horrible situation. They were old school, so his dad had worked for the Postal Service his entire life. His mother never worked, outside of the house. She did the house cleaning and she did the cooking, right, and all that. And she was going downhill first. So this now left retired dad to attempt to do the house cleaning and the cooking, none of which he'd ever done before, and he's descending into dementia as well. What do you do? Especially when dad says, hey, we got it made, we got it taken care of, no sweat, right? And my buddy Tim comes home, he goes to his parents' house every other weekend, and some of his brothers do the other weekends to check in on the weekends because they live a short distance away. And Tim walks into the house and he smells something burning, and there's something on the stove. Who knows what it was? But the fire's under this pot full blast and everything's burned away. And mom is not aware at all. She's sitting there in front of the TV. Dad's sitting there next to her, and it's like, Mom, Dad, what's going on here? And they're oblivious. They could have burned themselves up. What do you do? Right? So you have to go through this process of assessing competence. Let's look at some components of that. If we ask a psychologist to perform an evaluation, if a person's competence is in question, psychologists really have 4 criteria they need to determine. First of all, if it's about a decision making, then can an individual understand basic info relevant to the decision? That's like, can you live on your own anymore, or do you need to move to an assisted living facility? Right? One of the first things I pushed on my mom, because she had a nice house in Oceanside, and she loved her house, but it was becoming obvious that she couldn't really, the future said that she wasn't going to be able to take care of herself in her house. So I'm like, Mom, you know what, why don't we hire someone to come in? A couple hours a day, just come in, check on things, do some light housekeeping, maybe cook a meal or something. And she's like, no, I don't want anyone in my house. I don't need that. Well, we have evidence to the contrary, and she never did go for it. So we kind of skipped that step and put her into assisted living down the road, right? And I had to convince her of that, provide her with the evidence to do that. Now, can the individual understand the basic info relevant to making a decision? Okay, that's one criteria. The next is, can the individual apply the info to the situation and predict the consequences of various choices? Like, there's different options. We can have someone come in, right, and look in on you. You can move to assisted living. What are some other options, right? Can the individual use logical thinking to evaluate the pros and cons of various decision options? And note, that's core to this course, right, is can you use critical thinking, logical thinking, to evaluate pros and cons? Well, for some people as they age and perhaps descend into some form of dementia, they lose that ability. All right? Can the individual communicate the decision or choice to others? Interestingly, this was a tough one for my mom's husband, Howard, is he was suffering, from dementia. He was descending into dementia, but aphasia is one of the first symptoms that he began to have difficulty communicating. So I think that's Broca's aphasia, where he had a problem finding words. And it was okay for a while because, someone's speaking and they can't come up with a word, so we all know what they're trying to say, so we volunteer the word and they go, yeah, yeah, and they continue, right? But then if I'm not mistaken, then isn't it Wernicke's aphasia where they begin to lose the ability to understand language, right? So these are things that obviously psychologists can test for and put a number to. Now, the assessment of competence, then, most frequent when an individual refuses medical or psychological treatment, but we see also change of living, among other things. Research shows that unpacking, that is a treatment choice, might increase compliance, and that is really sitting down with the person, and a lot of times we say things like, well, here's a treatment and this will be good for you. And it's like, that ain't going to fit the bill here. What we need to do is really unpack each aspect of the treatment. And often we can get compliance in doing so in that manner. This represents a non-legal resolution to the conflict, and obviously for most of us we'd want it to be our first choice. But if it doesn't work, then we might have to go the clinical route, have tests to determine competence. Okay. Now this may or may not lead to civil commitment, and civil commitment is authorizing the custody and restraint of a person who, as a result of their mental illness, is a danger to themselves or others. So at some point, if the person doesn't necessarily agree, we may have to then go bump it up a notch in emerald speech, if you will, to bringing the courts in. Now, we have protections in this, and this is a significant protection via O'Connor versus Donaldson. Circa 1975, you can't be involuntarily committed for just being mentally ill, right? You must be dangerous as well. Now, dangerousness is dangerousness to others or dangerousness to oneself, right? And that can cause a change of state being imposed upon somebody. So 4 types of commitment procedures. First, right off the bat, is an emergency without a court order. So if we see someone running around the neighborhood, right, throwing things at other people and screaming profanities, etc., the police can come in, they can arrest them and take them to a mental hospital for observation. This is really how most cases start, and it's similar. The procedures are similar to an arrest. This was done to Britney Spears years and years ago, right? As part of her bipolar disorder. They were afraid that she would be a danger to herself or a danger to her child. So what do? The sheriffs come down and they effect an arrest, take her to a mental hospital for evaluation. Okay. Now, voluntary commitment, this is, I feel that I'm losing my grip on reality, things are tough, I'm going to check in and get checked out, right? And then notice with a voluntary commitment, I'm free to leave, but if they find evidence, in fact, that I may be a danger to myself or others, then it may then be elevated to the court system, and the court is going to order involuntary commitment. There's a hearing, there's representation, right, to determine if the individual's dangerous or too disabled. And notice that disabled is kind of a danger. It becomes a danger to oneself because they can't care for themselves anymore. The biggest determinant of commitment is grave disability. Okay. Notice the Department of Motor Vehicles also has provisions for this in most states. And this is something that's tough because, and I hope you don't have to go through this, but you know, we went through it with Howard. He lost his ability to drive. I mean, duh, right? And so, but he loves to drive and he loves his car. So what do you do? Because people don't want their rights taken away. They don't want their privileges taken away. And later, this is something we had to discuss at great length with my mom to get the car away from her. Because, you know, she was always an excellent driver, but at some point, she was deteriorating to the point where she was becoming less and less safe behind the wheel. And this is super dangerous because this is presenting a danger to innocent bystanders. You know, one of the indications we had with my mom is she would get lost. And I mean, she'd lived in Oceanside for 20 years, right? And all of a sudden she's getting lost for 2 or 3 hours at a time. I mean, literally that lost. And it's like, this has got to stop, right? And how to manage that, right? So there's a book, I think it was written by the AARP. Interestingly, my mom gave me the book. She sat me down one time when early before a lot of this was going on, excuse me. And the book was titled The Other Talk. It's an unpleasant topic. But The Other Talk, as a book, was full of great advice written by the AARP, right, American Association for Retired People. That we have to talk about what happens if one begins to lose their abilities, becomes less and less competent. So, outpatient commitment, okay, this may be ordered after a hospital stay. Okay, so that's about it. It's wholly unpleasant. The incidence of dementias seems to be increasing. There's like over 180 named dementias, Alzheimer's being just one of those. To think that you're not going to have to think about this is probably fooling yourself, and I'm sorry to say that. But the likelihood is that there will be someone in your life, right, who suffers one of these dementias, maybe to a severe extent. And you probably already know that because it may already be occurring, right? And grandparents, great-grandparents, what have you. And then ultimately with parents. So let's talk, let's shift gears a little bit. Let's talk about dangerousness, but from a risk assessment point of view. Acts of physical violence or aggression by one person against another is the definition of dangerousness we're using in this slide. And psychological studies abound, right? Often this is, hey, should we release this person from the mental hospital? And to what extent might they be dangerous to themselves or others? And this is when we engage in risk assessment, when clinicians try to predict who's likely to behave violently in certain circumstances using available data and combining it with research findings. Problem is that dangerousness among mentally ill is rare, and it's really hard to find good data about prediction. So a couple global kind of observations here, which you're going to probably laugh a little bit and think, these are not really all that valuable, at least some of them. When are the predictions by clinicians most accurate? Well, when predicting in the short term, and that kind of makes sense, what's going to happen in the next week or two, right? When predicting dangerousness in settings where a clinician knows about an individual's past behavior, and I have 2 rules, baseline rules in psychology. What's the best predictor of future behavior? Past behavior, all else being equal. Rule number 2, not as applicable in this circumstance, is you can't change people. People can change if they want to, but you can't change people. So, 2 rules in psychology, maybe worth the price of admission to this course, I don't know. Maybe I'm overselling it. So, past behavior. When the prediction considers person past history of violent behavior, and this is the best predictor, and notice that's in line with rule number 1 that I just gave you. When prediction made from people with statistically high rates of violence. Although I get kind of anxious about this because this is then kind of looking at group level stereotypes, perhaps, and some of us have a hard time going there necessarily. So take that last one for what it is. Who's going to be violent? Well, guess what? People with a prior history of violence. Duh, right? So conforms to rule 1. Younger patients tend to be more violent. Youth and violence, youth and aggression, that hormonal rush often is implicated in that. People who have a history of relationship instability might tend to be more violent, especially if, right, there was relationship violence. Pattern of alcohol or drug abuse. And this is an interesting one. I think that this one needs some refinement. Let's face it, I think there are certain drugs that predispose people to violent and aggressive behavior, and other drugs that maybe do the opposite. There's some people in my neighborhood that I know who went through a period where Xanax was all the rage, and they were all about Xannies and Xanny bars and all this other stuff. And I don't see them as getting too violent because most of them just took too much Xanax and passed out. So not necessarily encouraging violence. I think most cannabis users don't demonstrate violence under the influence to the same extent. Alcohol, man, it really is associated highly with violent behavior and aggression because of its the nature of reducing inhibitory influence of the prefrontal cortex. So I might think of acting aggressively, but think about the consequences and say, no, I shouldn't do that. But alcohol shuts off the prefrontal cortex, diminishes inhibition potential, so people act on their impulses to a greater extent. Meth is a great lubricator for violence and aggression, right? Gets people jacked up. So different drugs operate differently in that regard. Major mental disorder. Okay. This one though, man, you're going to talk to an awful lot of people who have strong clinical training who are going to take strong issue with that statement, right? As stigmatizing the mentally ill as aggressive when maybe they aren't. So take that one with a grain of salt. Early problems with adjustment in home or school, and this might be then demonstrated in terms of conduct disorder, right? As leading to antisocial personality disorder. People with history of escape attempts from custody. Well, yeah, duh, right? So, hey, who's here? You remember that little book report from Gift of Fear? Gavin de Becker? Here's another photo of de Becker, right? De Becker is often, and de Becker Associates, hired to make risk assessments. That is, hey, we're thinking about hiring this employee, but we have concerns that this employee, once fired, might choose to violently retaliate against the organization or someone in the organization. We'd like you to come out and do a risk analysis, a threat assessment, and advise us on how we should terminate this employee. And this is something that de Becker and Associates does regularly, to the point where they've developed the JACA prediction technique. What is JACA? Well, it's, does the person have perceived justification for retaliation or revenge? Now notice, this is not, do they have justification? Does the person perceive that they would be justified in settling a score, so to speak, right? To what extent are there perceived alternatives or the lack thereof? If you're going to fire someone who's been within an organization for 22 years and they feel they have nothing else going, right, then that could be, problematic. If OSU decides that they want to fire me tomorrow, it's like, I'm 63 years old. I'm contemplating retirement anyway. I would just as soon, hey, if you fire me, I'm going to sit down and I'm going to write a few books I got in my head. I have alternatives. I don't, my wife works and she makes good money. I have alternatives, right? This is not, my job isn't my be-all, end-all. My job is something I love to do. Oh my God, I can't think of anything that I love to do more than teach. But not being able to teach is not the end of my world. I will have alternative things that I can fascinate myself with. So, perceived consequences. And to the extent that someone believes there will be no consequences or that the consequences don't matter, then they may be more likely to engage in retaliatory behavior. And then perceived ability. That is, do they have the ability to do it? And if we're firing someone and they say, you haven't heard the last from me, I'm going to come back and I'm going to settle the score, and you find out that they have 16 guns at home, Well, the perceived ability is relatively high at that point in time, and you might want to consider it. So high justification, no few alternatives, lack of consequences, high perceived ability, all predict greater likelihood of violence. And this again comes from the gift of fear. So if I haven't sold you on that book yet, maybe I have at this point. And this takes us to homework 8, part 4. Okay? For the creatively minded among you. Okay, so I don't know how you're splitting up your work and your team projects, etc. But 1 or 2 people take this one on. Using DeBecker's JACA model, craft a story of a fired employee that ticks all the boxes to the max on DeBecker's 4 JACA criteria. Depending on your fiction skills, this can go 2 to 3 paragraphs. Done well, it can exhibit excellent story quality that allows DeBecker's criteria to be fully expressed in their realistic extreme. Right? So let's keep it real. Imagine doing DeBecker applying a JACA threat assessment on an employee. Create the scenario. This is an employee that's fired or being fired, and then describe this situation in a way that each one of the 4 JACA elements is expressed. Boom, boom, boom. And the word comes back. We got high risk. We better be careful. We better increase additional security, observation, etc. ultimately as the goal of this, right? Make it real. Make it engaging. Because I checked before I did this. I grade this homework assignment. So I'm doing homework 8. I want you to wow me. I want you to entertain me. I want to have a good time reading this. So there is homework 8 in its 4 parts. There is the assessment of risk for civil within a civil context. So I hope you guys have a great day. We'll talk later. Bye.